In 2026, millions of California drivers may unknowingly be driving under a different set of rules than they did just months ago. Quietly enacted legislative changes are reshaping how traffic enforcement works across the state. Some of these updates involve higher penalties. Others redefine what constitutes a violation. But here's the question. Are these new rules simply modern safety measures, or could ordinary drivers find themselves facing unexpected fines under regulations they didn't even realize had changed? Let me know your thoughts in the comments below. California has long been considered one of the most heavily regulated driving environments in the United States. With nearly 27 million licensed drivers and some of the busiest highways in the country, lawmakers routinely revisit traffic statutes to address safety, technology, and infrastructure concerns. According to records from the California State Legislature, multiple transportation-related bills were introduced and passed during the 2024-2025 legislative sessions, with implementation timelines extending into 2026. Official summaries published by the California Department of Motor Vehicles indicate that several amendments to the California Vehicle Code are scheduled to take effect beginning January 1, 2026. These updates range from modifications in distracted driving enforcement to new compliance standards for emerging vehicle technologies. While some changes are administrative in nature, others carry financial penalties that may significantly affect everyday drivers. One of the most discussed updates involves enhanced enforcement mechanisms for distracted driving. Under existing California law, handheld phone use while operating a vehicle is prohibited. However, legislative analysis reports indicate that 2026 enforcement revisions clarify evidentiary standards for citations and increase repeat offense penalties. According to committee reports, lawmakers cited public safety data linking distracted driving to thousands of injury collisions annually. Another area drawing attention is automated traffic enforcement expansion. Several municipalities have sought authorization for broader use of speed safety camera systems. While California historically limited automated enforcement tools, recent legislative amendments authorize pilot programs in designated jurisdictions. Public records show these programs are subject to strict guidelines, including signage requirements and revenue transparency provisions. One interpretation of these measures is that they represent a proactive attempt to reduce traffic fatalities, which federal data shows increased nationwide in recent years. Another perspective raised during legislative hearings is that expanded automated enforcement could increase citation volume, raising concerns about due process and equitable implementation. It is important to note that these programs are governed by statutory language specifying administrative review processes. Drivers cited under automated systems retain the right to contest violations, and agencies are required to provide photographic evidence. This discussion is for informational purposes only and not legal advice. In addition to enforcement changes, vehicle equipment standards are also evolving. Beginning in 2026, certain categories of commercial and passenger vehicles must comply with updated emissions or safety certification rules adopted by state regulatory agencies. According to public notices issued by the California Air Resources Board, compliance timelines vary depending on vehicle classification and model year. Failure to meet these updated compliance standards may result in registration holds or fines, depending on the circumstances. However, enforcement procedures differ between individual drivers and commercial fleet operators. The regulatory framework distinguishes between intentional noncompliance and administrative delays, which may affect penalty assessments. Insurance-related requirements are another focal point. Legislative updates reflect adjustments to minimum liability coverage thresholds for certain vehicle classes. According to bill analyses published by the Legislative Analyst's Office, the rationale behind these changes is to account for inflation and rising medical costs associated with collision claims. One interpretation is that higher minimum coverage limits better protect accident victims. Another view raised during policy debates is that increased insurance thresholds could raise premium costs for drivers. Public statements from consumer advocacy groups reflect differing opinions on how these adjustments will impact affordability. As these laws move closer to implementation, public awareness becomes critical. Historically, changes to the vehicle code receive less media coverage than high-profile criminal or civil legislation. Yet traffic violations affect millions of residents annually. Court administrative data shows that traffic infractions make up a significant percentage of filings in California's trial courts. Key turning points in the legislative process included committee amendments, clarifying penalty structures, and procedural safeguards. Official transcripts from floor debates reveal discussions focused on balancing public safety with fairness in enforcement. No evidence in legislative records suggests that the primary objective was revenue generation. Rather, lawmakers consistently referenced safety statistics and modernization goals. Still, critics argue that unintended consequences may arise. For example, increased fines can disproportionately impact lower-income drivers. Some advocacy organizations have proposed graduated penalty systems based on income, although such proposals were not included in the final enacted bills. As 2026 approaches, the Department of Motor Vehicles has indicated plans to publish updated driver handbooks and public awareness campaigns. According to agency statements, educational outreach will be conducted both online and through renewal notifications. However, whether this outreach will reach every driver remains uncertain. Another legally significant aspect involves administrative appeals. Under California law, drivers cited for infractions generally have the right to contest charges in traffic court. Some automated enforcement programs may allow administrative review before formal court proceedings. Legal scholars note that procedural protections must comply with constitutional due process standards. Court precedent from prior automated enforcement cases across the United States has emphasized the importance of clear notice, evidentiary reliability, and the opportunity to challenge citations. While California's statutory language attempts to address these concerns, implementation practices will ultimately determine how disputes are resolved. At the heart of this issue is a broader question about how transportation law evolves in a state experiencing rapid technological and demographic change. Electric vehicles, rideshare platforms, and semi-autonomous systems are becoming more common. Lawmakers argue that traffic statutes must adapt accordingly, yet adaptation often brings complexity. Drivers accustomed to long-standing rules may overlook subtle statutory revisions. Even minor adjustments, such as revised fine schedules or clarified definitions, can have financial consequences if misunderstood. So, what does this mean for the average California driver? It means awareness may be as important as compliance. Reviewing official DMV publications, monitoring renewal notices, and understanding local pilot programs could help avoid unexpected penalties. Given the facts presented in legislative records and agency statements, do you believe these 2026 updates primarily enhance public safety, or do they risk placing additional burdens on everyday drivers? Share your perspective in the comments below. And if you want ongoing fact-based breakdowns of major legal developments affecting drivers across the United States, consider subscribing for future in-depth analysis. As we move deeper into what these 2026 changes mean in practical terms, it becomes important to separate headlines from statutory reality. According to legislative summaries published during the 2025 session, lawmakers emphasized modernization, public safety, and technological adaptation as the primary motivations behind these reforms. However, when any regulatory change affects millions of drivers, the real impact is measured not in policy language, but in daily enforcement. Let's begin with penalty structures. While some violations remain classified as infractions, fine schedules for certain repeat offenses are being adjusted. Legislative analyses indicate that enhanced penalties primarily target repeat distracted driving violations and specific safety-related infractions. Under California's Vehicle Code framework, base fines are typically accompanied by state and county assessments, which can significantly increase the total payable amount. In practical terms, what may appear as a modest statutory fine can result in a much larger financial obligation after mandatory assessments are added. One interpretation of these increased penalties is deterrence. Lawmakers frequently cite traffic collision statistics when advocating stricter enforcement measures. Another perspective, raised during committee hearings, questions whether escalating financial penalties meaningfully change behavior or simply increase economic strain. This is where enforcement discretion plays a critical role. Police officers retain discretion in issuing citations versus warnings in many routine situations. However, automated enforcement systems, where authorized, operate differently. When speed safety cameras capture a vehicle exceeding a posted limit beyond statutory tolerance thresholds, citations are generally processed through administrative systems rather than officer-initiated roadside stops. Under the pilot frameworks approved for select jurisdictions, agencies must follow detailed procedural safeguards. These include visible signage warning drivers of automated enforcement zones, public reporting requirements on citation data, and mechanisms for administrative review. From a legal standpoint, due process protections remain central. Drivers must receive adequate notice of the violation, access to evidence such as photographic documentation, and an opportunity to contest the citation. Courts have historically scrutinized automated enforcement systems to ensure constitutional compliance, particularly under the 14th Amendment's Due Process Clause. It is important to clarify that this discussion is for informational purposes only and not legal advice. Another area that may affect drivers involves insurance compliance and reporting standards. As minimum liability thresholds adjust, insurance carriers must update policy structures accordingly. According to public policy summaries, the intent behind revised minimums is to better align coverage limits with modern medical and property repair costs. However, higher minimum requirements may result in premium adjustments. Industry analysts have noted that while not all drivers will see immediate increases, market recalibration often follows statutory insurance reforms. One interpretation is that enhanced coverage improves financial protection for accident victims. Another perspective is that increased costs could disproportionately impact drivers in lower-income communities. Vehicle equipment compliance is also evolving. Updated emission standards and safety certification requirements apply particularly to commercial operators and certain categories of fleet vehicles. While individual passenger drivers may not face immediate changes beyond standard inspection protocols, those operating vehicles within regulated categories must monitor compliance deadlines carefully. Failure to comply can result in registration suspension, administrative penalties, or inability to legally operate within state jurisdiction. Regulatory agencies have stated that outreach efforts will precede enforcement deadlines, but awareness remains essential. Turning to court procedures, traffic infractions in California are typically handled in traffic divisions of the Superior Court. Drivers cited under new 2026 provisions retain the same procedural rights available under existing law. This includes the right to contest the citation, request trial by written declaration, or appear in person depending on the violation. If automated enforcement expands as outlined in pilot programs, administrative review processes may serve as an initial step before formal court proceedings. Courts reviewing contested citations will examine whether statutory procedures were followed and whether evidence meets required standards. Legal scholars frequently emphasize that traffic law, while often perceived as minor, operates within the same constitutional framework as other forms of state enforcement. Notice, opportunity to be heard and evidentiary reliability are foundational principles that apply equally in traffic cases. Beyond fines and enforcement mechanics, broader technological considerations are shaping these reforms. California remains a leading state in electric vehicle adoption and semi-autonomous driving technology development. As these technologies evolve, legislators continue evaluating how existing traffic statutes apply to emerging systems. While 2026 updates do not overhaul autonomous vehicle law entirely, regulatory agencies continue issuing guidance on compliance standards. Drivers operating advanced driver assistance systems are still legally responsible for maintaining control of their vehicles under current statutes. One recurring theme across legislative debates is adaptation. Lawmakers argue that traffic regulations must evolve alongside technology and safety data. Critics caution that rapid regulatory change can create confusion if public education efforts do not keep pace. So what should drivers realistically expect? First, awareness will be critical. Reviewing official DMV updates, monitoring renewal notices, and understanding local enforcement policies can help avoid unexpected penalties. Second, documentation matters. In the event of a citation, preserving notices, reviewing evidence promptly, and understanding available procedural options can make a meaningful difference. Third, context matters. Not every statutory update will affect every driver directly. Many reforms target specific behaviors, geographic zones, or vehicle categories. From a broader civic perspective, these 2026 changes reflect a larger conversation about how states balance safety, fairness, and enforcement efficiency. Traffic fatalities remain a significant public policy concern nationwide. Legislators often face competing pressures: reduce collisions, protect due process, modernize infrastructure, and maintain equitable enforcement. Given the verified legislative records and official agency summaries, there is no indication that these reforms were enacted without procedural debate. Public hearings, committee reviews, and recorded floor votes form part of the legislative history. However, implementation outcomes often depend on how agencies execute statutory mandates. This brings us back to the central question of this video. Are millions of drivers unprepared? Possibly. Not because of hidden provisions, but because traffic law updates rarely receive sustained public attention. Unlike high-profile criminal reforms or headline civil legislation, vehicle code amendments often pass with limited mainstream coverage. In my view, clearly labeled as commentary, the risk is not that drivers are being targeted, but that many may simply be unaware. Awareness gaps can translate into financial consequences, even when laws are enacted through proper legislative channels. But ultimately, interpretation depends on perspective. Do these 2026 updates primarily strengthen public safety in a state with some of the busiest roadways in the country? Or do they create additional compliance burdens that drivers must navigate carefully? Given the statutory framework, enforcement safeguards, and implementation plans outlined in public records, where do you stand? Do you believe these changes strike the right balance between safety and fairness, or should additional protections or outreach measures be considered? Share your thoughts in the comments below. If you found this breakdown helpful, subscribe for future legal analyses covering traffic law updates, constitutional rights, and real-world enforcement issues explained clearly and responsibly. Because when it comes to driving in California, understanding the law isn't optional, it's essential.